Hi, everyone. Welcome. We're going to let a few more people trickle in before getting started. Welcome to the Family Justice Initiative Anti-Racist Lawyering in Practice webinar. All right, I think we'll go ahead and get started. Hi, everyone. I'm Alex Sinney. I use she, her pronouns. I am a staff attorney at the ABA Center on Children and the Law in the Legal Representation Projects team. I'm joined today by colleagues Amelia Watson with the Washington State Office of Public Defense and Phyllis Strickland from Children's Law Center of California. I'm speaking to you all today from Chicago, Illinois, which is traditionally the ancestral and unceded territory of the Council of the Three Fires, which are the Ojibwe, Ottawa, and Potawatomi nations. Many other tribes, like the Miami, Ho-Chunk, and Sac and Fox tribes, also called this area home. We honor and pay respects to the elders and descendants of these Indigenous communities, past, present, and emerging. And we acknowledge that the settler colonization resulted in the land seizure, disease, subjugation, slavery, relocation, broken promises, and genocide of these Indigenous communities. This acknowledgement demonstrates our responsibility and our commitment to truth-telling and healing, and the reconciliation to elevating stories and culture and communities of Native people. I recently moved to Chicago and found out that there is a First Nations garden not too far from where I live that I plan to visit before it gets too cold for me to do so. But I want to encourage you all to use a tool that will be dropped in the chat to look up the area that you all are tuning in from and to really try to think of creative ways to connect and uplift the communities, Native Indigenous communities, in ways that promote either public knowledge or donations and uplifting of these communities beyond just looking at where you are. And with that, we will go ahead and talk about the Family Justice Initiative, which is an initiative and a collaborative founded over 10 years ago now, based on the idea to increase access to high quality multidisciplinary family representation in child welfare cases. The work of FJI focused initially on multiple aspects that have shown to improve quality legal representation for youth and parents in child welfare cases, focusing on things like management and supervision of attorneys, caseload numbers and getting those to a manageable level, litigation strategy, and appellate practice. FJI has worked in each of these practices and continues to work with demo sites on the implementation of these practices. And it was out of some of that work, as well as work with actual families and youth involved in the system, that the Anti-Racist Lawyering Initiative was developed initially as a toolkit, but as you'll hear later from both Amelia and Phyllis, that was something that eventually grew into a much bigger everyday practice. And that's reflected in the name of the resource that you all are here to learn more about today. It's something that we hope you will engage in constantly in an evolving way and not just something that stays static in time. And so the resource that you'll hear about today reflects that idea. And with that, I'll turn it, and this QR code that's up on the screen will take you directly to the webpage. Different links will be dropped in the chat throughout the session today that you can use to directly go to different resources, but this will take you to the general webpage if you want to follow along while we discuss some of the resources. And with that, I'll turn it over to you, Amelia.
Thanks, Alex. I'm Amelia, and my pronouns are she and her. Today, I'm joining everyone from Olympia, Washington, which is the traditional unceded lands of the Squaxin and Nisqually and all Coast Salish people who call this land home. I'm glad to be with you today to be able to introduce the Anti-Racist Lawyering website to you all. This website was developed by FJI's Race Equity Work Group. That's a multidisciplinary group of legal professionals from across Washington State. The effort started with a recognition that systemic racism and other forms of racism show up in our world, show up in our court systems, show up in child welfare. Research and statistics on disproportionality and disparity show this. We know this. And we felt it was important to create a comprehensive site focused on disrupting racism in the area of practice that we work in. Fundamentally, we wanted a website that was directed and influenced by those that have been impacted by the child welfare system. We believed legal practitioners have an ongoing duty to continue to learn and educate ourselves, and that includes on topics of race and racism, bias, and we wanted to better understand how this shows up in our court system and how it was impacting our workplace, our advocacy, how it was impacting ourselves and our relationships with others. And with that in mind, the website was developed to include practical strategies and approaches to reduce bias, both inside and outside of the court system, at both an individual and a systems level. Next slide, please. With that, before we delve more into the website, we wanted to do a quick poll with you all to get a sense of who's in the audience with us today. And so I'm hoping that the powers that be can populate a question for you that you should be seeing. To what extent, if any, have you used anti-racist lawyering in your practice? Please take a moment and fill out this poll for us so we can get a snapshot of where we're at in the room today. Okay, I think folks should see responses that we have. It looks like about 21% are saying that they haven't used anti-racist lawyering in practice, to this variation where you see folks at the some of the time level. I've used it a little bit. I've used it frequently. I just want you to know, for everyone that's here, this website was created with you in mind. And we're really excited to be able to delve into this more today. With that, I'm going to turn it on over to Phyllis.
Hello, everyone. I'm Phyllis Strickland, Director of Diversity, Equity, and Inclusion at the Children's Law Center of California. My pronouns are she, her, hers, and I'm speaking to you from the unceded and still inhabited and cared for land of the Gabrielino Tongva, Kichi, and Chumash people, which is also known as Los Angeles County. I acknowledge, honor, and pay respect to the elders and descendants, past, present, and emerging. Again, we think such acknowledgements are so important that we put this as a practice area within our strategies. But let's take a minute and talk about a few things. Amelia lifted up some really important things that we considered when we met. There were a group of 15 to 20 of us, many different people at times, and we thought critically important that we center the work on perspectives and the voices of parent and child client. And how did we do that? We took their narratives, we shared the material with them, even though they were written for lawyers and interdisciplinary staff. We wanted to make sure that it was significant to those clients, what was presented and how it was presented. So there was a lot of writing and rewriting and et cetera of the initiative. We wanted to make it easy to use. We wanted to, as Amelia pointed out, have practical tools and approaches that people can use. You don't have to use the entire website. You can start at various places within the website, depending on your particular need. And then this last point here, we recognize that users of the site would be from various jurisdictions, and practices would be very different in those jurisdictions, and the laws would be different. And that we would have very new practitioners, as the survey we just had showed, to people who've not used this material, people who have thought about using it, and others who are much more experienced practitioners. And even our experienced practitioners and very learned and seasoned practitioners can integrate concepts and wording, et cetera, in their practice to really focus on it being anti-racist in nature. And we're going to talk about that further. Next slide. Now, as we talk about, or as you engage in the material, it's very, in my opinion, I'm going to use the word heady. And it's because we're thinking, we're reading, we're analyzing, we're figuring out how the material works where. And I thought this might be good for us to pause. In addition to all the lawyering and the thoughtfulness that we have to give to this material, I want us to pause a minute and focus on feeling. This particular picture is one of a tool that's used in courageous conversation. And it often places us in a thinking quadrant or we're acting. So for example, someone could take this material and just say, I'm going to do this, that, and the other with the material. I'm going to write a motion, or I'm going to argue in court. We asked you to please not act without knowing. Be sure you know and understand what you're doing so that it can be effective. And then there's the believing and feeling quadrant. The part I want to slow down a minute is to read something from the preface of the initiative. And I'd like you to listen and hear me as we walk in the shoes of the narrator, the children and parents that have been involved and impacted by child welfare. If we don't get this point, it's important to be centered and really understand and lift this part up and design our practices accordingly. Imagine how it would feel to be taken from a stranger's home and dropped off. What if you and your siblings were dropped off in separate places? As a young child, how might you process the different smells of that home, the different foods, the different words, languages, behaviors, routines, and practices? What happens over time with those feelings and the tears and pains of being separated from the things and people most important to a child, to a parent, or to a relative? As practitioners in our rushed practice, when we use legalese and acronyms, which have no meaning or very little meaning to our clients, how dismissive must it make them feel? The strategies in this initiative are meant to address these types of questions and lead us to be bold in our advocacy. So to listen and to hear. Next slide. So what is anti-racism and what is not anti-racism? So the way we used it in this initiative is very broadly, because it's not just about race. It's about discrimination in all of its phases, those things that emanate from racial prejudices, biases, and it's not just against races per se, but ethnicities, religion, gender, sexual identities, socioeconomic classes. These are the things that come up in dependency practice nationwide. And then us understanding the intersectionality that occurs with our clients, because their identities may not be just may not be, is often not just socioeconomic, for example, that status, but it can also be their sexual identity compounded by other differences that create even greater obstacles. And then the impact of these disparities. Again, in our busy practice, and we're going about our routines and learning, etc., do we stop and think about both the short and the long-term impact on particular groups? I talked about children being placed the day of or soon after into a home that's not their own, but there's also long-term consequences to groups, particularly LGBTQ plus clients, that are life altering. And again, we want to use words like that are life altering, because this is the impact is important. So our intent is one thing, but the impact on children, families, parents, communities is extremely important. Next slide. The other thing I want to say about anti-racism and then anti-racism lawyering, we were very careful to, when we talked about that broad definition, if you think about Native Americans, some people consider them a race. We were very clear that that can be a problematic descriptor, even though it's used in that way. And we saw Native Americans, American Indians, as a political and legal entity with their own sovereignty. And that narrative switches how, hopefully, those that are Native American are viewed, because they're not othered, they are their own sovereign people. And what does that mean? And what do those laws mean? And what does our advocacy then mean? Particularly since ICLA is well integrated into what we do as practitioners. So an anti-racist lawyer, as you can see, this is an active role of dismantling racism. It's not just saying, I'm not going to be racist. I'm just going to be neutral, and I'm going to do good work for all of my clients. Great. Do it for all your clients, but forcefully and very intentionally work to dismantle racism, be they conversations, be their wording and policies, etc. Commit to replacing anti-racist policies, practices, and procedures in all of the decisions we make. And you'll see some examples as we go through some of the strategies. Next slide. So now I'm going to spend just a few minutes and talk about guiding principles, I hope, for practitioners. If anyone or a colleague of yours is feeling antsy or not committed to or not sure why one would practice in an anti-racist faction, think about what's in, for example, the Model Rules of Professional Conduct, the ABA rules. And they talk about competent representation. And that means competent representation requires legal knowledge, skill, thoroughness, and preparation. So you're not just shooting from the hip when you're a competent legal professional. In Rule 1.3, it talks about taking whatever lawful and ethical measures are required to vindicate your client. 2.1, as an advisor, a lawyer may refer not only to the law, but to other considerations such as moral, economic, social, and political factors that may be relevant to the client's situation. So as zealous lawyers, as zealous anti-racist lawyers, we are looking at all of those practices to advance the well-being and the advocacy for our clients. And then in Rule 8.4, it's a misconduct rule, but it also says lawyers may engage in conduct undertaken to promote diversity and inclusion. So next slide, let's turn to our interdisciplinary staff. And this one is taken very specifically from the ethics.
Phyllis, we have sorry, it's Jay. We have a question about your definition of anti-racism. why are we including such a broad spectrum of discrimination, not just race? And wanted to give you an opportunity to answer that.
Okay, thank you, Jay. Because I'm just plowing on, aren't I? Because what we have found is that when these issues come up, it may not only be race. And I'm glad that question was raised. Race has to be identified, and I'll use the term isolated, because it's an area where people are uncomfortable talking about it. There's a lot of historical background and underpinning related to race. And so we certainly could just focus on race. But in reality, when I talked about the intersectionality of this, other things come into play. So, for example, if I have a client that is, their religious practice requires them to pray 3 times a day, that's what they would like to do. It may not have anything to do with race, but it may be in a broader category that is important to that client that I want to not disassociate from, but still be able to figure out and make the practice. Because again, these issues are raised in what's considered this normative, quote unquote, child welfare field, that everything is gonna go as planned. Return is a plan. Visitation practices are as planned. Reunification over these periods of time. But these issues to these clients are very personal. And therefore, race is not the only thing that's personal to clients. So that's why we did it broadly. And again, I will talk, if you think about the comment I made about Native Americans and that they're a sovereign nation, and there have been laws that have tried to, and arguments to pinpoint them into just a race so that they could deny some of their rights as a sovereign nation. And anyone might want to unmute and speak to that or put that in the chat. So that is the reason, and I hope I answered the question. All right, you can go back to it. And if not, you can raise your hand again, or we can get back to that discussion later. So now this is about ethics for the social workers. And there were several different points that are guiding lights, or you can hopefully incentivize people and are directive to others about the responsibilities of those in the social work field, not just those in agencies, but as our practices are multi-dimensional and interdisciplinaries are involved, including parent partners and peer advocates, etc. Here are some guiding principles and ethics for those that are in the social work, quasi-social work field. They talk about social justice, and that ethical principle is listed here. Social workers also, they have something about cultural competence. Social workers should demonstrate an understanding of culture and its function in human behavior and society, recognizing the strength that exists in all cultures. Do you see that type of language in the reports that you get from social workers? Or if you have social workers in your organization, are they writing from a strength-based perspective? And if not, to the former in particular, that would be something you would want to challenge and always raise up, that our clients should not be seen in this very limited perspective. But in fact, they bring many strengths, and their cultures often bring many strengths. And again, we're trying to, how can we change the narrative and our own beliefs about people? That's what a lot of this work is. So again, cultural competence, and there's one for the social workers on competence. The next slide, please. Another foundational area that's important to us is the constitutional right to family integrity. I was surprised when one of the lawyers in our firm mentioned that the judge, when she raised a constitutional rights issue, the judge said, counsel, we're in state court. I'm not sure why you're bringing the Constitution to this. Flabbergasted, right? And so for us, we want to make sure that underlying all of the statutory law, case law, that we're also looking at these constitutional rights to family integrity, and that is underlying an undercurrent and a foundational principle and law of what we're doing. And as you can read here, this liberty interest is rooted in the 14th Amendment. And it states that no state shall deprive any person of life, liberty, or property without due process of law. So one of the things in our practice, we're making sure that there is due process of law. Again, in this, oftentimes when you're just in the routine of practice, it can be easy to say, it might be easy to say, I didn't get notice of that, or I wasn't told X. But how much of that is really considered due process of law related to our clients, and should not be just skipped over and accepted as acceptable practice? Next slide. Again, this is a foundational principle talking about family integrity. And I wanted to highlight two things in particular. One, that the 2019, the AB policy on child and parents' right to family integrity, a really fantastic historical document that asserts that children and parents have legal rights to family integrity and unity. And I know for myself, I did not always fully understand that or look at that or consider that in my practice. Next, I'd like to highlight the ABA Resolution 606 that I hope most of you have heard about. And again, all of this material is in the glossary and elsewhere. But very extensive work was done by those in the ABA, including Prudence, who's present today. And it urges legal professionals to examine the history of Black children, parents, and kin, and our role in shaping that history, right? So there's laws, and if we look at them separately, they might not have the same impact and directive if we look at them together. And that's what our resolution, in a nutshell, 606 does. It helps us to look at this history over time, where a lot of our terminology came from, and a lot of our practices, and about the over-surveillance of Black families and the underinvestment in those populations. And as a result, so many different nationalities and ethnicities and races are caught up in this child welfare system because of the way it's been designed and shaped. And we don't want to be hopefully a part of continuing that. All right, next slide. Another foundational principle is self-reflection. Now, I know I just got from the heady thing of family integrity and constitutional law, but this is, again, a very important basis of moving forward in this work. We asked you to take the implicit bias test. Consider your own cultural history, and how did you learn it? And what did you learn? And how did you learn even child welfare practice? How did you learn the law and child welfare practices or social work practices? Who taught you those things, and what did you take away from it? Self-reflection means bringing awareness to your own actions, attitudes, and judgments. Racial dialogue is important in understanding another person's perspective and view of the world, but you also have to understand your own racial identity and cultural beliefs. And again, some of the practices we'll get in a minute will show that. Next slide. And as there is a document that is in the initiative, raising awareness of bias and racism. And there's a set of questions for lawyers. It was too large to enlarge, but here are just some examples of the questions. And not only are these questions you can ask of your client, but you can ask them of yourself as well in terms of what am I including and not including as I speak to clients, as I work within my organization, what's said and what's not said. Again, to give you some insight and self-reflection so that you can do this work. It's hard. This work is hard. It's arduous. You need a team. You certainly need someone you can reflect things back and share suggestions with. And we believe that this is an example of something that you can use, beneficially use in your practice. Next slide. And with that, I'm going to narrow down a bit and turn it over to my colleague, Alex.
Hi again, everyone. So just a refresher, this is where we are looking at on the webpage. You'll have all of these materials there, and we're going to focus in more detail on the strategies that are provided on the resource. So this slide is really just highlighting some of the practical approaches and resources that were put together with you all in mind, thinking about what you can lean on and pick from as you start to develop or further your anti-racist lawyering practice. So beginning the conversation with reframing language and taking a pause and interrupting when certain language is used either in reference to the families that you represent or even within your own office culture, speaking with clients as they interact with members of your interdisciplinary team. Data and research and the motions and briefs will be discussed in a little bit more detail later. Thinking about utilizing cultural experts, there are examples on the resource of ways that cultural experts have been used in cases, particularly an ICWA case, and a case that affirmed the requirement to present cultural experts prior to terminating parental rights of Indigenous families. The use of apology statements in different assessments, testimony, and oral advocacy. So thinking back to Phyllis's earlier points about professional responsibility and ethics and ways to incorporate those ethics that have been reflected in apology statements and different action items that have been presented by different organizations, thinking about ways to use that either in your direct or cross-examination to really lift up ways that these initiatives have either been implemented or not in favor of families and how that reflects poorly on the practice. And really the ability to assess the cultural and racial implications of families. Thinking about the appellate process, right? Anti-racist appellate process, and thinking of appeals really as a way to address repeated patterns of racial disparity that we see come up across cases, and different guides on the website, both on appellate practice generally, and also several resources that focus on, again, identifying those racial disparities and trends in that in appellate practice. And finally, the importance of narratives that I will talk about in a bit more detail in the next slide, and land acknowledgements, right? As Phyllis mentioned, really thinking about this as an opportunity for reframing and not just using land acknowledgements as a token or to display without actually having initiatives and efforts behind it. So thinking about it from a race equity lens, moving beyond performative and connecting and having genuine relationships with community members and Indigenous people. So this is one of the strategies that we're going to highlight before jumping into a few more. But thinking about, as I mentioned, the language that's used both in and out of the courtroom. This resource on the website provides different scripts that you can use in your role as an interrupter of different racist and biased incidents in the courtroom and elsewhere, and ways that you can address the harmful and problematic ways of speaking with or to families that you work with. specific examples of some anti-racist language that you can utilize in your representation, and ways to really promote client-led decision-making throughout the court process. There are some guides and documents that you can find there as well that help reframe some of these common tropes and common ways of describing families. And we'll talk about that in a moment on the next slide. But really thinking of this as a tool to use in interrupting certain instances as you encounter them in your representation of families. So some of these assumptions that we get at in this resource talk about, for example, families' ability to afford certain services or programs recommended by the agency because family members have access to things like iPhones, and really calling out the assumptions that come into play when folks are talking about this and thinking about financial status and the assumptions that are made either by service providers or others in the courtroom. Ignoring the fact that payment plans exist and other alternative ways of obtaining something like an iPhone are possible. Focusing on the reasons why something happened more than on the what of what happened. Thinking about phrases like non-compliance with a service plan, missing several visits, refusing to participate as examples that we hear often in court. But thinking about shifting that sense of blame that comes along with those kinds of phrases to providing a more holistic understanding of what's going on in a client's life, right? Highlighting that it requires taking a train and several buses to get to where they need to be in remote parts of town for a visitation, and really just trying to shift the way that certain things are being highlighted in a way that humanizes and really recognizes that this person lives a full life and it's not just this court case that is impacting different things in their schedule. Same thing with educating, using those opportunities to educate the court and those there about reasons why your client may have missed certain things, and again, accommodating their schedule and reflecting on the flexibility that we impose on clients and families, assuming that they are able to make afternoon calendar and different things like that when the grace afforded to attorneys and other court professionals in the room is extremely different. Highlighting client attributes, that kind of gets to the earlier point of really humanizing the person in front of the court and thinking through ways that things that may have been overlooked or even demonized can be used as an opportunity for people to connect and see the real family in front of them. And then really interrogating the difference between safety and risk. There are resources on the website that get to exactly that point, and really advocating for the agency, for example, to identify specific concerns and highlight particular risk factors rather than just using blanket statements to justify whatever action is being taken against the family. So this is a sample from one of the resources I mentioned earlier that really gets at some concrete examples of language and different court rituals, if you will, that disparage and dehumanize clients often routinely. And I encourage you to look at this resource not just as a way of substituting language and kind of just replacing words that we're using on a daily basis, but really thinking about why it's important to reframe the language that we're using. And really thinking about the ways that certain words and phrases that are commonly used and may not feel like a big deal to someone who's in the courtroom every day or operating within the legal scope every day, but can be really isolating and creating barriers between families, either amongst themselves and also between you and the families that you represent. So, for example, something that came up a lot during the development of this initiative was referring to attorneys by their surnames and addressing them by name in court, either when referencing them to the judge or just amongst co-counsel or opposing counsel, but then referring to clients by their role in the case. So using the term mother or father. In Miami, Florida, where I used to practice, it was common for attorneys to use the phrase a child and b child when referring to children in a sibling group rather than using their names. And as you can imagine, that's an extremely dehumanizing and really just yeah, just dehumanizing way to refer to human beings. The term birth mother, for example, is something that diminishes a continuing relationship with a mother between her and her children, and really kind of ignores the fact that this is a family that exists outside of the context of a given child welfare case. So really just trying to think about the reasons why we're honing in on the language rather than just thinking about substitutions that you can use. And this gets back to Phyllis's earlier point of really engaging in the self-reflection piece before using a lot of the tools that are provided on this resource. So as I mentioned earlier, these are the 3 of the 8 strategies that you can find on the webpage that we'll be talking in more detail about now. Again, the QR code will take you to those strategies on the webpage. So for the first one, the importance of narratives, this section of the resource really is the part where, as Phyllis mentioned, we highlight and really lift up the words of youth and families that we spoke with and who helped develop this resource. It's where those words live in the webpage, and really was the main motivating force behind this resource. And so we encourage you to take some time to actually read through these narratives and sit with them. But for the sake of time today, we're just going to pull some different pieces out to highlight for you today. So we know that many of you who are tuning in today have worked with children and families, likely for many years. And so a lot of what we're talking about today may feel either really small or insignificant, but I think it's really important to think again about the reasons why this is being highlighted and why this was a call by families and youth who have experienced the system to really look at the way that we're engaging with families. So really taking this opportunity to pause and recognize the long-term impact of some of these seemingly small actions or inactions that we take as advocates. So gaining perspective from the narratives, a lot of the narratives highlighted the need for communicating in safe and appropriate places. So for example, youth who were involved in foster care, having folks like social workers, guardian ad litems, their attorneys showing up at school and pulling them out to discuss cases or to discuss things that are going on, immediately put, a flag up to their classmates and teachers and others at the school, and was really viewed by them as a source of shame and invasion of their privacy. So really thinking through ways that we can engage with families and prioritize our schedules in a way that actually reflects what the clients would appreciate and what they would want. And issue spotting through the narratives, this is really getting at some of our training as attorneys and other multidisciplinary folks in the room to get at some of the crucial facts or relevant facts in a case, but really taking the opportunity to learn more about the people that we're working with, including asking about holidays, asking about family traditions, cultural practices, and coming at it from a place of curiosity rather than trying to establish a fact pattern or establish an argument in court, and really reframing what we may not deem a priority, which feels counterintuitive to the way that many of us were trained in the profession, but thinking through this information as if it's being shared, being something that's valuable, and that's something that a coworker shared that I think is really important to recognize, that if a family or a child feels the need to share something with you, it's for a reason, and really taking a moment to think about how that can be incorporated into your advocacy in court as well. And finally, increasing client well-being and engagement, right? So actively listening, this gets back at the earlier point, thinking of ways to engage that value your client's humanity and their real life outside of the court case. This requires a real openness to learning and being unafraid of asking questions that may feel uncomfortable at first. And that's something that this resource is hopefully getting at, and you can utilize in your own development of ways that you can interact with your clients. And just to highlight a few things that we pulled from the narratives, as I mentioned, we encourage you to really go back and take some time with these narratives in their fullness, but to just highlight a few things from folks who were directly impacted by the system, thinking about the awareness of what families are witnessing in the courtroom and courthouses when they're there. Oftentimes, there are relationships outside of the professional experience between opposing counsel, attorneys for the agency, attorneys for parents and children, and thinking about those dynamics of the members of the court team and how that might look to a client who doesn't understand that this is something that won't affect their own personal life and the decisions that are being made about the intimate details of their life that day. And thinking about ways to incorporate the preferences of youth clients, even with acknowledging that there may be very little that you personally can do or a shortage of foster homes that comply with some of the preferences that they've acknowledged, but really making sure that we're prioritizing their comfort and making sure that they feel heard in those decisions. And with the parents' narratives, we pulled a few things that were highlighted throughout about not allowing your own assessment as an attorney to decide whether a client is quote unquote polished enough to stand up and speak before the court, and not allowing your own assessments of what would be right for case strategy purposes to affect a client's ability to have their voice be heard by the people, again, making decisions about the intimate details of their life. It's our duty to prepare the client and explain any implications or consequences of speaking in court, but other than that, it's, as a family advocate, it's important to ultimately recognize that it is their lives and the value of their voice is paramount to any of the strategic implications. And so with each of these experiences that you'll read about more in the webpage, it's important to think of it as a duty to act on behalf of these families and, again, interrupt when things are happening in front of you, either in your office or in the courtroom. But we recognize that while this was developed for advocates and for members of multidisciplinary teams, so many of these resources can be used to just level with clients and be human with each other and connect on a human level, and engage in a way that you would with other people in your life, right? So in seemingly small ways, but really thinking about anti-racist lawyering as a way to change the way that you connect human to human throughout your practice day to day. And with that, I will pass it to you, Amelia.
Thanks, Alex. The next strategy we're going to focus on today is thinking through how you can bring data and potentially research into your advocacy through anti-racist lawyering. If you go to the website that has the section on data, you'll see some examples of links to the types of data that you can drill into. We've got some listed there. One might be if you're if you want to know what your state's Child and Family Services Review looked like and whether or not they had to enter a program improvement plan, you can link down into those. You can link into census information. You can get to both national information and some examples of state information. It's not really intended to be a all-encompassing list of data. It's really intended to give you kind of a snapshot of some different ways you could start using data in your representation. Next slide, please. And I think something to just kind of start with is that first time, if you haven't used data historically in your representation, it can feel like a heavy lift that first time. So what we've done is we have created an example hypothetical fact pattern that you can link to on that website that kind of talks through a issue with a family and then offers some ways you could think about incorporating data into advocacy for a family. Next slide, please. The next strategy kind of blends with the last strategy. We have a very meaty section on motions and briefs that we wanted to highlight today. It's got a lot of sample motions. There's a number of briefs that have been shared from practitioners nationally that had favorable outcomes that resulted in some strong case law. So we've kind of linked to those updates so you can see different ways that their litigation through motions and briefs impacted favorably. The motions and briefs section, it's kind of broken out topically. So if you're interested in thinking through the start of the case at opposing removal, you can go to a section and you can see some examples around that. It's a place to start if you are thinking about this topic for the first time, or you've already done lots of briefing in anti-racist litigation and you want to see how someone else has done it and maybe think, oh, maybe I want to incorporate this little bit. Many of the briefings include data and research. There's also a section at the end that is organized topically where you can be looking and thinking about issues around judicial implicit bias, caseworker implicit bias. There's links to articles and reference materials that you might want to use in a briefing. And there's also that same hypothetical appears on this site, and you can see some different ways you might think about incorporating a motion and brief into the hypothetical. Something to kind of keep in mind is this is a website that you can share with anyone. It's not just for our representation, but it's these briefs in and of themselves. If you don't have time, if you have a contested hearing in the morning and it is about enforcing ICWA, maybe you want to think about looking at one of these briefs and incorporating that into your oral motion to the court. Maybe you want to use it in your case negotiation going forward with the agency. There's lots of different opportunities to use this to not only educate the court, but educate ourselves, educate court partners, and think through different ways to incorporate these resources into your representation. Next slide, please. And with that, I think we also would like to do a poll. I know we've only focused on some of our strategies that we've included, but we wanted to get a snapshot sense of which of these strategies is speaking most to our audience today. And with that, I think we have the results so we can see the spaces where folks are interested in highlighting the practice. This is helpful to us, and it maybe gives us some ideas about where to move in next steps and highlighting some of the other strategies in future presentations. With that, I think we have a little bit of time left for questions.
Okay. So we do have a few questions. One is directed to those who represent youth. How do you balance hearing from your youth with lived experience that are more mature and grown up based on their experiences, with adultification issues with our youth of color?
I'll jump into that one, and then we might have some others in the audience that might want to speak to it. The balance for me would take into several factors. One, the agency of the client, trying to always respect their agency. Two, to not, if there is a situation where where adultification is happening in my presence, I would want to understand that concept and speak up on that. For example, there was a situation where a hearing officer made a comment about the client's looks and said something like, "Oh, you look much older than I thought," sort of based on what the allegations were. So knowing to speak up on behalf of the clients when that occurs. But third, not trying to, again, respect their agency, and this is their case and their life. So in my mind, it does not mean that I'm treating them like an adult, but that I'm sharing information with a client so that they can be helpful in making the decisions if they're old enough related to their lives. Obviously not an infant, but children that can speak and give information, to respect their voice, and listen to them is not putting adult tasks on them. And I know that that's probably a fine line, but I would consider those three things. Anyone else want to speak to that?
I think we have time for one more question. How do we call out racism or interrupt without being called racist ourselves, was a common question.
You can try and respond to that. I'm not sure I think that's going to show up in the conversation. And I think I've supported attorneys in my jurisdiction that have been called racist for calling out when they see racism showing up. I think we still have duties to lean into conversations, whether that's pointing out that I think bias is showing up in a social worker's perspective of a case, pointing out when parents of color do not have culturally appropriate experts to truly be able to support clients. And I think it's an ongoing conversation that we need to continue to have. We can reach out. There was another question about how do we train judges? Training judges on racism, implicit bias, how those things show up in our court systems are super important. And as parent attorneys, as children's attorneys, we also have duties to our clients to represent them within the system. I'm curious the other panelists' thoughts. I think it's continuing to lean into conversations and try to make sure that someone that I am representing is seen and has individually tailored services and the respect that they should have as part of the court process.
I think, yeah, the only thing I would add to that, Amelia, is just along the same lines, thinking about your role as an advocate, decentering yourself and the repercussions for you, and really centering those of your client, right? And thinking about the stakes of not raising something out of fear for what you may be called. But I think Amelia said it right with the need to really lean into conversation, and more than just a one-off comment, having actual conversations and opportunities for debriefing these things with colleagues and folks that you're encountering in this work.
And Jay, I think you wanted us to share that this is one in a series of presentations, webinars that'll be made. But in terms of answering questions via email, because the questions in the question box are anonymous. What were you thinking there, Jay?
Oh, for those who did put their emails, we'll follow up with them.
Yes, and thank you, Phyllis. That brings us to the end. And this is part of a series. I'm so glad you mentioned that. I forgot to say that at the beginning. This is the beginning of a series highlighting this resource. And so we look forward to diving into some of these other concepts that we didn't quite get to today. And as Jay mentioned, we'll be sure to get back to those of you whose questions we did not get to answer if you left an email. But with that, we say thank you so much for being here today. It was a pleasure talking about this with you all, and we look forward to many more questions in this discussion. So thank you.